Hello and welcome to my presentation for Week 5 of Global Law, an introduction to international law. My presentation will answer questions 1 and 3 of this week's study guide. What is private international law? What are the 3 main issues that are commonly dealt with? And what are the various sources of private international law? Let's get started. Before we begin, I'd like to start by acknowledging the traditional owners of the land on which I live and work, the Komabari people of the wider Yagamba language region. I pay my respects to their elders, past and present, and recognize that this land was never ceded. Sovereignty has never been surrendered. This always was and always will be Aboriginal land. Private international law, which is often referred to as conflict of laws, is a field that deals with legal questions that arise when more than one jurisdiction is connected to a dispute. It focuses on the rules, principles, and approaches that help courts decide which legal system should apply, and how foreign laws or judgments should be recognized. Even though it sounds highly global, private international law doesn't only apply between countries. In Australia, it very commonly appears in matters that span across state borders rather than international ones, so the term cross-border law is becoming more widely used here. The origins of this area of law can be traced back many centuries. Its earliest forms grew out of the informal customs of merchants who traded across different regions in Europe. Over time, these customs became more structured, particularly during the 12th century when trade expanded and there was a need for clearer rules to govern commercial dealings. The expression international private law is often associated with the work of Joseph Story, a 19th century American jurist who helped shape the modern understanding of the field. Although the system has changed significantly since then, the core idea remains the same: to create greater certainty and harmony in decision-making when disputes involve more than one legal system. Private international law plays a vital role in today's world of international and interstate commerce. Businesses often operate across borders, making it essential to have reliable legal mechanisms for handling contracts, transactions, and disputes. Where disagreements arise, private international law helps determine which court should hear the matter and which country or state's laws should be applied. It also provides pathways for resolving disputes, such as arbitration and litigation, which are now key components in international commercial practice. Importantly, private international law is not a universal system. Different countries develop their own rules, although many share similar ideas or enter into bilateral treaties to create consistency in certain areas. Australia, for example, has entered into treaties with several countries to help streamline cooperation. Despite this variation, private international law can still be applied and enforced by ordinary courts, meaning it operates within the everyday legal system rather than specific international tribunal. One essential point to clarify is that private international law is considered part of the country's internal legal system. In Australia, as in many common law countries, it is viewed as a component of domestic or municipal law, not a branch of public international law. Public international law governs relations between states, whereas private international law governs disputes between private individuals or corporations that happen to involve multiple jurisdictions. Overall, private international law provides an organized framework that helps court deal with cross-border legal issues fairly and consistently. Its long history and continued development reflect the ongoing need for predictable rules in a world where people, businesses, and legal problems increasingly move across borders. Private international law mainly deals with 3 interconnected questions: jurisdiction, choice of law, and the recognition and enforcement of foreign judgments. These issues come up whenever a legal dispute has a cross-border element, whether that involves different countries or, in Australia, different states. The first issue is jurisdiction. This is about deciding which court actually has authority to hear the dispute. When parties, events, or properties are spread across more than one place, courts must determine whether they are appropriate forum to deal with the matter. This step usually comes first, because the court needs to confirm it has the right to hear the case before anything else can happen. The second issue is choice of law. Even once the court accepts jurisdiction, the next question is whose laws should be applied. Different legal systems may have different rules, so courts need to have a structured way to work out which law governs the situation. For example, imagine a contract negotiated in France, signed by parties living in different countries, but carried out in Australia. A court would need to determine whether French or Australian law applies when assessing the contract's validity or any alleged breach. The third issue is recognition and enforcement of foreign judgments. This concerns whether a decision made by a court in one country or one Australian state should be accepted and enforced by another. Without this mechanism, court judgments would lose their effectiveness once a party moved elsewhere. Recognition and enforcement allows decisions to carry weight across borders, which is especially important in areas like international family law, commercial disputes, and cross-border contracts. Together, these three issues create a framework that helps courts handle disputes involving multiple legal systems in a predictable and fair way. So what are the sources of private international law? Unlike public international law, which relies heavily on treaties and formal international agreements, private international law develops from a mix of domestic and international influences. This means that there isn't one single global code. Instead, different jurisdictions draw on several recognized sources to resolve cross-border legal issues. One key source is national legislation. Each country sets out its own rules that guide courts on questions like jurisdiction, choice of law, and enforcement on foreign judgments. In Australia, for example, these rules are embedded within ordinary statutes and the common law, rather than in a single consolidated act. Another important source is court decisions, or judicial precedent. Courts often rely on earlier cases to guide how they handle new disputes with foreign elements. Over time, these decisions shape consistent principles around which laws should apply or when a foreign judgment should be recognized. Private international law is also influenced by international treaties and agreements. A major example is the suite of Hague Conventions, which aim to harmonize laws across different countries in specific areas like child abduction, service of documents, or international contracts. When a country signs and implements these treaties, they become a part of its domestic approach to cross-border disputes. We also look to customary international practice, which develops from long-standing patterns of behavior between states. Although not as prominent in private international law as in public international law, custom still plays a role where there is widely accepted international standard. Additionally, courts sometimes rely on general principles of law, fundamental concepts that appear across many legal systems, such as fairness, good faith, or access to justice. These principles help fill gaps where formal rules are unclear. Finally, scholarly writings, such as treatises and academic commentary, have historically shaped private international law. Authors like Joseph Story, Dicey, and Morris significantly influenced the development of the field, and modern academics continue to guide interpretation in difficult or emerging areas. One practical example of how these sources operate is contract law. A contract is usually governed by the law of the place where it was formed, unless the parties clearly choose a different legal system. That rule comes from a mix of common law precedent, long-standing commercial practice, and treaty-based principles. Together, these sources create frameworks that courts use to resolve disputes that cross borders and involve multiple legal systems. To bring everything together, private international law gives courts the tools they need to navigate disputes that cross borders, whether international or interstate. By working through questions of jurisdiction, identifying the most appropriate law to apply, and determining whether foreign documents should be recognized. This area of law helps create consistency and predictability in situations where more than one legal system is involved. Its rules are shaped by a range of sources, including national laws, court decisions, international agreements like Hague Conventions, long-established practices, and the work of legal scholars. Although each country approaches it differently, the overall aim remains the same: to manage cross-border disputes fairly and efficiently. Understanding these foundations helps explain why private international law is essential in an increasingly interconnected world and why courts rely on it to bridge the gaps between different legal systems. Thank you.